had an inability to discuss with any sort of sophistication the legal process, what everyone's roles were.
A Siders family member rushed to the hospital, questions about his mental state swirling, as prosecutors bring in reinforcements to investigate and take these child endangerment cases to trial.
You already knew something was wrong here, didn't you, before I even say his name, before I even get into the medical records nobody's allowed to see? You already felt it. That gut instinct. That thing where you look at a photo of a smiling family and something in your stomach just turns. That's what this case does to people. I'm going to walk you through what's actually happened in the Siders case out of Ohio, because a lot has changed since the last time we talked about it. And I need you to stay with me here, because some of this is going to make you angry, some of it's going to confuse you, and one part of it is genuinely sad, no matter what you think about anyone involved. Here's where we left off. 16 children, one house. A search warrant there for about the 4 misdemeanor charges everybody keeps talking about. 16 kids, ages 1.5 to 18, taken out of that home on our street and scattered into hospitals across the state.
The charges, as I've been telling you, stem from Vinton County deputies and agents with Ohio's Bureau of Criminal Investigation finding Gary Jr. and Elizabeth's 16 children in the house on Omer Street more than a week ago. It was June 30th. When deputies and agents said they went to the house to execute a search warrant as they investigated a crime that has yet to be disclosed. The search warrant was not part of the 4 misdemeanor public indecency charges that Gary Jr. faces. I want to be very clear about that. 16 children between the ages of 1.5 and 18 were found in that home, and some, according to prosecutors, were in bad shape. All were taken to hospitals throughout the state, and all have since been released and placed in foster care.
All of them released now, all of them in foster care, and the parents, Gary Siders Jr. and his wife Elizabeth, both charged, both pleading not guilty, married back in 2008 in West Virginia, when Elizabeth was 15 and Gary was 18.
One of the big questions here is, why did Gary Jr. and Elizabeth have so many children when prosecutors say they couldn't take care of them properly? I told you earlier this week that Elizabeth and Gary Jr. were married in March of 2008 in West Virginia. Elizabeth was just 15 and Gary Jr. was 18. They had a child a short time after they were married, and then more children came after that, including 2 premature twins who died shortly after they were born in November of 2022. They were conjoined.
Let that sit for a second. 15. But that's not even the part I want to start with today, because something happened this week that changes the whole shape of this story. Gary Siders Sr., the grandfather, he fell.
Here's Vinton County Prosecutor William Archer on what happened to Gary Siders Sr. and why the judge granted him this recognizance bond. Take a listen.
Now look, people fall. That's not news on its own, but this happened during a police transport, on the way to what was supposed to be a preliminary hearing for him and his wife, who go by Gary and Lynn, on their own 16 counts of child endangering. He fell. He was taken to the hospital, and while they were checking him out for the fall, they found something else. Something more serious. Nobody will say what.
And so it was agreed that we would do a recognizance bond so he could get the medical treatment that the doctors say he needs, and won't cost the county that money.
So Gary Sr. fell on his way to court, and then a more serious medical condition was discovered at the hospital, although no one is commenting on that condition.
And here's the thing, though. The prosecutor didn't fight to keep him locked up. He agreed to a recognizance bond. No cash required, so Gary Sr. could get treatment. The reasoning given publicly was blunt.
First, let me stress, the community is not at risk because of this bond. Yesterday, as you all know, the cases were scheduled for preliminary hearing. During the transport, Mr. Siders fell and had a medical issue that required treatment and assessment. O'Blenna's Hospital was where he was taken, and it was determined at that point upon some tests that O'Blenna's did that Mr. Siders Sr. has a serious medical condition that requires specialized care in a hospital outside of this area. Practically, and I don't know if you folks know this or not, but when defendants are housed in county jails, it is the county's responsibility to pay for the medical care. Prisons are for defendants who have been convicted. Then the state pays for it. But he's still an innocent man that has not been convicted yet. So the county was going to be on the hook for his medical care. And again, based on the information that we were provided, his medical care could potentially bankrupt Vinton County. We were not going to put that burden also on our local taxpayers.
His care could bankrupt the county. Taxpayers weren't going to eat that bill for a man who, in the eyes of the law right now, is still innocent. Make of that what you will. I have thoughts. I'll get to them. So now we've got an elderly man, reportedly in a wheelchair, hospitalized for something serious enough that his own attorney won't discuss it, released on a monitor, and facing the exact same 16 felony counts as his son and daughter-in-law.
If he is released from the hospital, he will be given a GPS monitor. Right now, Gary Sr. and his wife, Christina Siders, who actually goes by Lynn, face 16 counts of child endangering. Gary and Lynn's son, Gary Siders Jr., of course, and his wife, Elizabeth, face the same charges. All have pleaded not guilty to the counts.
And this is the part nobody talks about. His attorney, a man named Dorian Baum, has now filed something that changes everything about how this case moves forward. A motion for a competency evaluation.
His lawyer is asking to receive a mental health evaluation and to determine whether he could be not guilty by reason of insanity, meaning, can Gary Siders Sr. appreciate the wrongfulness of his actions because of a mental illness or other mental infirmity? Dorian Baum wrote, "It was clear to counsel that the defendant exhibited significant confusion about the legal process, was unable to describe the specific roles of the various participants in the court proceedings, including even the role of counsel to aid in his legal defense, and was unable to describe even basic facts about himself. The defendant was generally unable to maintain a clear and consistent train of thought throughout the interaction and was clearly struggling to understand what is going on. The defendant's conduct leads counsel to believe that the defendant may be suffering from significant mental health issues and that competency may be an issue and clear impediment in the defendant's ability to aid in his own defense. Collateral information has seemed to confirm that the defendant suffers from significant health issues, including a decline in mental function and functionality, which would be consistent with counsel's observation of the defendant."
And alongside it, a request to explore whether Gary Sr. could be found not guilty by reason of insanity. I sat down with Baum directly, and what he told me was not what I expected.
Well, thank you for having me. I appreciate the time.
Yeah. So what is the very latest on your client? He's been hospitalized at first from a fall, which sounded serious enough for somebody of his age. But now they've discovered a more serious medical issue that can't be discussed because of privacy rules and things like that. But I mean, he's been released on the bond. You were asking for a modification of the bond. So what's the latest?
Yeah, thank you again for having me. As I said, or as you noted, I can't really talk about certain things due to privacy issues, not only HIPAA, but also just his own privacy. We're all entitled to certain privacies. But I was asking for a modification of bond. As I've already sort of said elsewhere, I was able to meet with him after the court hearing didn't take place, but the court hearings were scheduled. I was able to finally meet with him, and upon meeting with him, I did see additional concerning behaviors. As you'll probably get into, I filed a motion for competency.
Right.
NGRI. So I saw some of those continuing concerning behaviors, but also saw some physical issues. Mr. Siders himself, expressed discomfort. So I asked the staff there.
He said when he finally got to meet with his client, after a hearing that never happened because of the fall, he saw things that concerned him, not just physically. Mentally, he described a man who couldn't explain the roles of the people around him in his own case, couldn't describe basic things about himself. A man who, in Baum's words, struggled to hold a consistent train of thought through their entire conversation. Now here's where it gets interesting. Baum was careful, almost too careful, not to call this dementia in any official sense. He kept saying he's not a doctor. He kept saying he can't diagnose. But then he used the word anyway just to help viewers understand what he was seeing. He said most of us have met someone with dementia. We recognize that person. We say things like, well, they don't know what they're doing. That's not a legal term. That's a human one. and it's the one that's going to stick with people. I need to pause here for a second, just for a second, because somewhere in all of this, underneath the charges and the bond hearings and the legal terminology, there's an old man in a wheelchair who fell down on his way to face 16 counts tied to his own grandchildren.
When I met with him, he was also in a wheelchair. It's my understanding he has pretty significant mobility issues. It's my understanding he has some hip issues. So, in every video recording I've seen of him and every interaction I've seen with him, both in person and on video, he has had difficulty with mobility. So being in a wheelchair full time would not be surprising to me if it were in fact the case. I don't know that for a fact. Obviously, I don't live with him, but it does appear he has those issues.
Right. Without going into anything that would violate privilege or, your duty to him as his lawyer, I mean, what exactly did you see that was very concerning to you? I mean, when you said, "Hey, I'm Dorian Baum, I'm your lawyer, and I'm here to help you," I mean, did he even understand what that meant?
He obviously understood a person greeting him, but again, as I noted in my motion, he definitely had some confusion about the process, about what was going on. He had an inability to discuss with any sort of sophistication the legal process, what everyone's roles were, which again, as I've said in here and elsewhere, competency is a bedrock. It's a bedrock precondition to be able to move forward in any criminal case.
And whatever he did or didn't do, whatever he'd understood or didn't understand, that image doesn't leave you easily.
And if you don't have that, you just simply can't. I'm going to circle back around to what you already asked also. Is he a danger to the community? I would have suggested he's never been a danger to the community. And certainly in his present condition, he isn't. He is not dangerous. What I would consider him to be is a sad and sympathetic character, primarily because of his general level of confusion and both the mental health and physical issues that I was sort of seeing. And when you asked what I was sort of observing, it was very similar to what we've all seen during the preliminary hearing and his behaviors and mannerisms there, where there was just a general lack of confusion, inability to hear very well, certainly mobility issues, and an inability to sort of in any way discuss with sophistication what was going on around him. And so now, after having now filed my motion, we're going to have a professional psychiatrist or psychologist go in and speak with him so we can actually establish what his baseline is.
I don't think it's supposed to. Okay, picking it back up, because here's what Baum explained about how this actually plays out in court, and it matters. First, they determine if he's competent right now.
You first have to determine if they're competent. If they're not competent, then, of course, you have to determine whether they are restorable to competency or not. If they're restorable or potentially restorable, they will send them to a mental health facility for restoration services to see if they can, in fact, be restored. If they're not restorable, then they are just deemed incompetent. And then the court is left with sort of other questions of how are we going to handle this moving forward with an individual who's not competent. If they are, in fact, found to be competent, then they will do the second part of the evaluation, which is, were they legally insane at the time? And again, you do a law show, so I'm sure you understand, but perhaps your viewers don't. Legally insane is not some colloquial throwaway term. It's a term of art. It's a term that says, did the person understand the wrongfulness of their actions at the time it was allegedly committed?
If he's not, they figure out if he can be restored to competency, sent somewhere for treatment to get him there. If he's not restorable, he's simply deemed incompetent, and the court has to figure out what happens to a man who can't participate in his own defense. If he is found competent, then and only then do they move to the second question. Was he legally insane at the time? And Baum was very clear, this isn't the throwaway internet version of insane. It's a specific legal term. Did the person understand the wrongfulness in what he was doing when he did it? He gave 2 categories of people he's seen qualify for that in his career. People hearing voices, believing they're in another reality, and people whose minds have simply declined, degenerative conditions, where they genuinely don't track what's happening around them anymore. Which one is Gary Sr.? Baum won't say. He says that's exactly why the evaluation exists. But I asked him something else. I asked if there's been some kind of decline. Because here's what's bothering me, and maybe it's bothering you too. There are photos, Facebook photos from 2023, of Gary and Lynn looking clean, looking well, looking like any older couple you'd see at a Sunday service. Christina, Lynn, whichever name you know her by, her page is full of images of Jesus, the Lord's Prayer, across her profile picture. And then there's whatever law enforcement described finding when they went into that house. Those two pictures do not match.
I'm looking into the possibility that there might be a religious component to all of this. Christina Sider's Facebook has images of Jesus and the Lord's Prayer. She posted about God frequently and has a cross as her profile photo on one of her accounts. There are also photos of Gary and Lynn, that's Christina, from 2023, where they look well and clean. The photos are nothing like what was described by law enforcement after their arrests. And I've told you that I've learned that Children's Services in a county near Vinton once visited Gary Jr. and Elizabeth Siders. And then the couple moved with their children, I'm told, to avoid social workers, fearing their children would be taken away from them.
And I don't think they're supposed to. Baum told me he can't speak to any of that beyond what's already public. He said he hasn't received information about a diagnosis, past or present. But he said something that stuck with me. If the family is saying this isn't who these people used to be, then maybe there's something to that he simply doesn't have access to yet.
Does it seem to you that there's been some type of, in your limited investigation of this case, there's been some sort of decline over the last couple of years, possibly, with your client? Because I see pictures on Facebook of him and his wife where they are clean, they look well, but obviously it looks like something may have changed in the last couple of years.
I can't comment on anything more than what's been posted on Facebook that you've probably already seen. I would agree that there are other pictures and there's statements made. I personally have not received any information that relates to either his specific mental health diagnosis or what he was in the past or what he is now. I don't have any of that information. So if the family knows that this is not what they were at one point, then perhaps there can be something in point to that I don't know.
Now, a family member did come forward. Someone connected to Gary Sr. and Lynn said, plainly, this isn't how they raised their kids. That's it. That's all we have right now. But you don't say that unless something changed. You don't go on record defending the way you raised someone unless you're watching that person become unrecognizable to you. And this is where I have to admit something. This case gets to me a little differently than most. Maybe it's the 16 kids. Maybe it's the age gap in that original marriage. Maybe it's just the wheelchair. I don't know. But something about this one feels personal in a way I wasn't expecting when I started digging into it. Let's talk about Elizabeth for a second, because she's not sitting quietly either. Her attorney, Tommy Stolle, filed a motion this week asking the court to lower her $300,000 bond. And the argument is worth hearing in full, because it's not what you'd expect from someone facing charges this serious.
Stolle filed this motion and wrote that Elizabeth has cooperated with the investigation. Attorney Stolle wrote, "In this case, the defendant is a 33-year-old mother with no known criminal history. Given the defendant's lack of a criminal history, she has never been charged with failure to appear before a court for a criminal proceeding. There has been no indication that the defendant has been anything but cooperative with law enforcement since the initiation of this case. As such, the defendant does not pose a significant flight risk. The defendant has indicated that she will provide the court every assurance necessary, that she will appear to all future hearings and will comply with the terms set forth by this court. Should the defendant be released, she is willing to wear a GPS monitor, to check in person with her assigned bond officer at whatever frequency this court deems appropriate, and to provide the court with a stable living address within Vinton County or a surrounding county."
He wrote that she's 33, no criminal record, never missed a court date in her life. He said she's cooperated with investigators since this whole thing started. He said she'll wear a GPS monitor, check in with a bond officer as often as the court wants, and give the court a fixed address in the county or nearby. He said she wants nothing more than to reunite with her kids, and that reunification is impossible if she doesn't show up to court, so why would she run? And then the part that really lands. He wrote that she simply doesn't have the money, that the entire basis of the case against her and her husband was that they were living in extreme poverty. So how, he's asking, can the court expect her to post a bond she was never going to be able to afford in the first place? on charges rooted in the very poverty that made bail impossible. You already know what I'm about to say. That's either a genuinely sympathetic legal argument, or it's a very convenient one. Maybe it's both. I'll let you sit with that. What the motion didn't mention, and this is something I want you to notice, is her current health situation. Her pregnancy, left out entirely. Make of that what you will too.
Now, Stolle did not write about Elizabeth's current health situation or her pregnancy, but Stolle says Elizabeth doesn't have the ability to post any cash for bail. And there's more. Stolle wrote, "The defendant understands that the charges alleged in the amended complaint are serious. However, the defendant has denied all allegations. The defendant has a vested interest in appearing for future court hearings in an effort to clear her name. There has been no evidence provided by the state that the defendant is a risk to herself or the at-large community. Further, the children living in the defendant's home have been removed by the state, so there is no risk to any alleged victim of the charges the defendant faces. Through conversations with counsel, the defendant maintains it is her principal desire to reunite with her children. She understands that reunification of any sort is an impossibility if she does not appear before this court. The defendant is indigent. The basis of the amended complaint was that the defendant was living in a home which exhibited extreme poverty. As such, while in many cases some bond may be necessary to ensure that the defendant appears as ordered, it seems clear that in this particular case, the defendant does not have the means to post any money as a bond, and they have been unable to post the current bond as it has been set."
We still don't know if the prosecutor is going to fight this request. That's still coming. Now here's the part where the case gets bigger than just one family. There was a family member, one of Elizabeth's older brothers, who went online after all this broke and basically dismissed the whole thing. Said it's a slap on the wrist. Said you can't be charged for ignorance. Said his sister and her husband did that his words, their IQ. He blamed low intelligence. He blamed circumstance. He said everything is misunderstood. I'm not going to sit here and pretend. Comment didn't make my blood boil a little. 16 kids. Some of them, according to prosecutors, in bad shape when they were found. And someone's response is to blame IQ like it's an excuse instead of a red flag. We all knew this kind of reaction was coming. Somebody always shows up to defend the indefensible.
Into what? We don't know. Now he's blaming low IQ for this situation. Elizabeth's brother wrote on social media on July 7th, "This is what I think. Slap on the wrist. You cannot be charged for ignorance. The horror stories is not true. Nothing is true. My sister and her husband really did do the best to their IQ. Allowance is the one to blame. Low IQ, getting that money, similar, just like me, only on plus 500 app. I be chasing that money with a bit higher IQ. Everything is misunderstood. Their hygiene, low IQ. The man of the house is responsible at most. He is the leader, leading followers. That's what I think."
You know it just like I know it. But underneath that ugly comment is a real and uncomfortable question this case keeps raising. Why did Gary Jr. and Elizabeth keep having children, 16 of them, when, according to prosecutors, they couldn't properly care for the ones they already had? That's not a rhetorical question I'm asking to be dramatic. It's the actual question investigators are trying to answer. And here's a thread that connects everything back to the beginning. Children's Services in a county near Benton reportedly visited this family once before, years ago, and after that visit, the family moved, not across the country, just far enough, it seems, to get out from under that particular set of eyes. The prosecutor's office has described it plainly. They were hiding these children. Sit with that phrase for a second.
The Attorney General said they were basically hiding these children. Prosecutor William Archer said during a press conference that Gary Siders Sr. and Christina Siders were the only Siders family members that he is aware of that were receiving welfare benefits. I am looking into whether Gary Jr. and Elizabeth were also receiving these benefits and how many times they may have actually encountered children's services over the years.
Hiding children. Not losing track of them. Not struggling and falling behind hiding them. That's not a family that didn't know help existed. That's a family that ran from it. And there's still an open question nobody's answered yet. Whether Gary Sr. and Lynn were the only ones in this extended family receiving welfare benefits, like the prosecutor stated publicly, or whether Gary Jr. and Elizabeth were pulling from the same well while also apparently avoiding the very system meant to check on their kids. That part of the investigation isn't finished. We don't have that answer yet. Now, let's zoom out, because this case isn't happening in a vacuum. And I think this is the part where everything starts to make a little more sense. Benton County is one of the least populated counties in the entire state. They don't even hold grand jury sessions every month. More like every other month, which is exactly why this whole preliminary mess happened in the first place. Small county, small resources. Big, ugly case that could bankrupt them if they're not careful, literally, in the case of Gary Sr.'s medical bills. And now, because of the scale of what's being alleged here, outside help has been brought in. An assistant attorney general and a prosecutor from a neighboring county have both been asked to step in and assist. Free of charge, according to the prosecutor. No cost to local taxpayers. That tells you something about how big this has gotten. A rural county prosecutor's office, reaching outside its own walls, calling in reinforcements with, in his words, extensive experience specifically in child cases. You don't call in that kind of help for something small.
The Attorney General did offer assistance and has agreed to provide an assistant AG. Her name is Kara Keating, and yesterday a motion was filed to have her appointed special prosecutor to assist me in the prosecution. Also, Annika Collins, who is a Highland County prosecuting attorney, I also filed a motion to have her appointed as a special prosecutor, as she was an old colleague of mine when I worked in Highland County. Both of these women are outstanding prosecutors with extensive experience in child cases, and they will do nothing but help our team progress through these cases.
And that assistance is being provided free of charge, so the taxpayers won't be on the hook for it.
So where does that leave us right now, today? An elderly man in a wheelchair waiting on a psychiatric evaluation that could determine whether he ever faces trial at all or whether he's sent somewhere to be restored to competency first. A pregnant mother of 16 asking the court to trust that poverty, not danger, kept her from posting bail. A family with religious imagery all over their social media pages that doesn't match a single word of what law enforcement described finding in that house. And 16 children spread out across foster homes in this state, waiting for our system to figure out what happens to them next while the adults in their lives fight over bond amounts and mental competency. Nobody in this case has been convicted of anything. I want to say that clearly because it matters legally and morally. Everyone here has pleaded not guilty. That's not a technicality I'm going to gloss over just because it's an uncomfortable case to sit with. But here's my honest question for you. And I actually want you to answer this in the comments, because I read every single one. If a family hides from the very services meant to protect children and only gets caught because of an unrelated search warrant, what does that tell you about how many other families out there are doing the exact same thing right now without anyone watching? I don't have that answer. Nobody does yet. That's the part that keeps me up at night with this one. Tell me what you think happened in that house. Tell me what you think should happen to Gary Sr. if that evaluation comes back the way his attorney seems to expect. And tell me, honestly, what you'd want done with those 16 kids if you were the one deciding. I'll be back the second anything new breaks on this. And with this family, something always does.